welcome back to the channel, and thank you for watching. In this video I have to address something that I see on Twitter occasionally, and when it does fire up it's quite, well, fiery, and it does spark this conversation which gets a little bit shouty, as I read this morning. Literally, quote, "It was a bit shouty." So I'm going to address this without addressing the account that it came from, because there's no purpose in that, there's no benefit in that, but I am going to quote the tweet itself. And so bringing that on screen now is this tweet here that says, "When Amber won in the UK, very little changed." Now, just pausing at that moment, I'm going to come back to it, but the phrase itself is fundamentally wrong and misconceived, with all respect, because Amber did not win in the UK. I'll come back to that point in a moment. Now, this talks about petitions firing up to have her fired from Aquaman. Well, this is a democracy, and if people want to raise such a petition and that's what they want to petition for, that's down to them. So there's really nothing wrong with that. They could equally petition the same against Johnny Depp for whatever they wanted to. So whichever side they supported, in inverted commas, they could raise any such petition that they wish. However, when it comes on to the social media trolling got worse, well, I don't agree with social media trolling, but it really depends on what your definition of trolling is. If someone were to say that what I'm doing here is trolling, they'd be wrong, because I'm commenting on something that is publicly stated by somebody, and I'm giving my views on it and what I think about it, whether it's right or wrong, and so on, except that I'm backing it up with certain evidence, which I'm going to come back to in a moment. Next, it talks about what Johnny Depp did after he won in the US, and he did win, at least for what he was claiming he won. There was obviously the small win for Amber and on what she was claiming, but by all accounts, public opinion is that Johnny Depp won, and certainly won that which he was claiming. He went on tour, released an album, landed a role, and was invited to the VMAs. So whatever Johnny Depp did after that is frankly no one's business, and nothing to do with the trials, quite frankly. Whatever he did after that was entirely up to him. But coming back to the point here, which is fundamentally wrong, misconceived, or just plainly misleading, I'm not sure which, but either way, the phrase Amber won in the UK is wrong, and for reasons I'm going to make expressly clear, in my view, here by referring to the lower court judgment. So you might recall this is the judgment from the original trial in the UK. At paragraph 576, the judge refers to arguments made by Mr. Sherborne that it was somewhat unfair to Johnny Depp as the claimant in this case, because his effective opponent was Amber Heard, and yet she was not a party. Now, quite rightly so, the judge points out on this line here, it is of course right that Miss Heard is not a party to the proceedings. So Amber didn't win anything in the UK trial. Just to make that absolutely clear, she was a witness, not a party. The judge goes on, because she's not a party, she was not obliged to make disclosure. Now, this is where, with the greatest respect to the learned judge, I, in my view, believe that there is literally a contradiction within this paragraph alone. And allow me to explain. The judge points out correctly that Amber Heard was not a party to the proceedings. However, going back to the argument itself, Mr. Sherborne made the argument that it was unfair to Johnny Depp because the effective opponent was Amber Heard, because obviously the underlying issues was between those two as parties. She had no obligation to make disclosure, and she provided information to the defendants of the case at different times and at her choice. So if the argument is, as it was, that she was the effective opponent, and yet she had no obligation to make disclosure, and she provided information at her choice at different times, the judge said that he was not persuaded that those comments carry any weight. However, Moving further down into paragraph 576, which is still on screen here. I might be able to make it slightly bigger so you can probably see it a little bit more clearly. This section here, just after I've highlighted this bit in red. This bit in red, by the way, was because Johnny Depp had applied for, or rather his lawyers had applied for third-party disclosure on his behalf against Amber Heard. Third-party disclosure, of course, is disclosure, or what you might think of as discovery, from a third party, someone who is not a party to the proceedings. The application was unsuccessful. Judge said no, that evidence is not coming in. However, here's where I believe, in my view, my respectful view, here is where the contradiction lies. In this latter section here, reading just after this red bit, Mr. Depp has not been short of legal advice. He would, I can assume, have been advised as to the consequences of suing the defendants against whom the claim is brought, but not Miss Heard. It was a matter for him, with the benefit of that advice, to decide if he wished to pursue the claim against these defendants. The consequences, there's that word again, of him doing so are that they, not Miss Heard, are subject to the obligations of a party to make disclosure. There's been no suggestion that the defendants have failed in that duty. So no suggestion that the defendants to this case, i.e. News Group Newspapers and Dan Water, no suggestion that they had failed in their duty of disclosure. However, here's where the contradiction for me falls, in case it's escaped you. It is nuanced, but in case that's escaped you, in the first half of the paragraph, the judge says that he's not persuaded that the argument carries any weight, that Amber Heard was the effective opponent and yet not a party and therefore no obligation to make disclosure. However, the judge then talks about there being consequences. Doesn't say what those consequences are and doesn't go into any detail, obviously, but there is a hint, at the very least, by saying that he would have been advised as to the consequences, so acknowledging that there are consequences of suing the defendants instead of Amber Heard. And it's a matter for him, with the benefit of that advice, to decide if he wished to pursue the claim against them. So to me, the reading of that is very plain to say there are consequences of suing these defendants instead of Amber Heard because she's not obliged to disclose. She's not subject to those same disclosure requirements. So if that being the case, how can there be no weight in the argument? For me, my interpretation is that there must be weight in the argument if there are consequences. Her not being a party and not being subject to those disclosure obligations, and the judge hinting at the very least that there are consequences and Johnny Depp must have been advised as to those consequences, and with the benefit of that advice deciding whether or not to pursue the claim against the defendants, knowing the consequences of him doing so, that Amber Heard is not subject to the obligations whereas the defendants were. For me, there must be weight in the comment, weight in the argument that she was the effective opponent if there are consequences. So that's just my view on that situation. But just coming back for a moment to tweets like this, when Amber won in the UK. And for me, this is a fundamental misrepresentation of what happened in the UK and why there is lots of social media trolling, and there is social media trolling in both directions. There's been a little bit against me, and I don't tend to engage. I just block them. If I view it as a troll, I just block it. Now and again, I will interact. I won't name call, just as other lawyers won't name call against me if I'm making arguments. I made a comment the other day on Twitter that our role and our job as an advocate is to fearlessly and fiercely make an argument for that which we are commenting on or for whom we are making those arguments. It's not about name calling. It's not, or it shouldn't be. And it's not about being angry with each other, and advocates will, at least in my experience, be professional and not do that. But tweets like this and comments like this are fundamentally wrong. And this is why. Because looking at this paragraph, even by itself, in isolation, judge confirms in his own words that she was not a party to those proceedings and not obliged to make disclosure. I do feel, however, that she was the effective opponent, particularly after the Virginia trial and the rest of the evidence that was heard and the jury's verdict. I believe, and in my view, it was shown quite conclusively that she was the effective opponent in the UK trial, and therefore this whole argument for me is enough to satisfy the test to reopen appeals, which is to avoid a real injustice. And that is the wording of the test to reopen the appeal. The petition to do so is in the description below. Please go and sign that if you haven't already. Just as a side tangent, lots of people have said, why not a Parliament petition? Well, Parliament and the judiciary are supposed to be separate anyway. Law 101, separation of powers. Parliament is not going to interfere with the court system regardless. So a petition to Parliament is going to do nothing. Petitiononchange.org can at the very least bring attention to the issue and hopefully, potentially persuade the courts to invoke an action of its own motion. It would be unprecedented. It would be very interesting to see. I very much would like to see that happen because I believe in the justice system and the rules there being for a reason. And to avoid a real injustice, that's what those rules, particularly in respect of appeals and reopening of appeals, including permission to appeal, are there for. That's what those rules are there for. You would like to think that you can trust in those and that they will reopen if it is to avoid a real injustice and there is no other available remedy. So if you are on Twitter and you read these things, what I would suggest you is don't just argue back and forth with them. You correct them if needs be, but this need not be a full-blown argument. It need not be unkind, unpleasant, unprofessional, much less rude and trolling. So I hope that was useful to you. I hope that has sought to clarify if anyone was in any doubt as to who the actual opponents were and who I believe the effective opponent was in that trial. I hope you found that interesting. Thank you very much for watching. Do like this video and subscribe if you're not already done so. And check that you're not unsubscribed. YouTube does that for some reason when it's trying to clear out, ironically, trolls and spam bots and things like that. So make sure you're still subscribed. And as always, thank you very much for watching.